Welcome back to Protecting Trade Secrets. I'm Professor Seth C. Orenberg. In the previous two lectures, we examined misappropriation, how UTSA and DTSA define wrongful conduct, and what defenses destroy claims, and injunctive relief, including why courts grant injunctions reluctantly, what limits they impose, and how the DTSA's ex parte seizure remedy works in extraordinary circumstances. Now, in this final lecture of Module 6, we turn to monetary remedies and strategic enforcement choices. Injunctions stop future harm. Damages compensate for past losses. But calculating damages in trade secret cases is notoriously difficult. Causation is speculative. Apportionment is complex, and comparable evidence is scarce. Courts offer three damages theories: actual loss to the plaintiff, unjust enrichment to the defendant, and reasonable royalty. Each addresses a different dimension of harm, and plaintiffs can choose the theory that best fits their evidence. This lecture addresses four core questions. First, how do courts calculate damages under each theory? And why are trade secret damages so hard to prove? Second, what enhanced remedies, exemplary damages, and attorney's fees are available under UTSA and DTSA, and how do they differ? Third, when should plaintiffs choose damages over injunctions? And how does the Calabresi Melamed framework help counsel make that strategic choice? Fourth, what role does criminal enforcement play under the Economic Espionage Act? And when should companies involve the FBI? By the end, you'll understand that damages are a critical enforcement tool, but one that requires sophisticated evidence, expert testimony, and strategic thinking about what plaintiffs can realistically prove. Let's start with the challenge of proving harm when trade secrets are misappropriated. Trade secret damages are conceptually straightforward but practically elusive. The plaintiff must show what the misappropriation cost them, or what it gained the defendant. But unlike contract breaches, where damages flow from clear obligations, or patent infringement, where royalty rates are often documented, trade secret cases involve information that was never publicly valued, never licensed on standard terms, and never bought or sold in transparent markets. Three problems dominate. First, causation uncertainty. Did the defendant's success come from the trade secret or from other factors? Marketing, distribution, pricing, brand reputation, timing. If a former employee joins a competitor and that competitor launches a successful product, how much of that success is attributable to stolen knowledge versus the competitor's own resources? In Bianco versus Globus Medical, a 2014 Eastern District of Texas case, Dr. Bianco disclosed a spinal implant design to Globus Medical during collaboration discussions. No agreement was reached, but Globus later commercialized a similar device. The court awarded damages based on the licensing value Bianco lost, what he could have negotiated if Globus had acted lawfully. The key was that Bianco could show the design's value and Globus's use of it, but in many cases that causation is murkier. Second, apportionment challenges. If the defendant used the trade secret and their own innovations, engineering, or market knowledge, how do you separate the value of the stolen information from the value they created themselves? Courts require plaintiffs to apportion damages, to isolate what portion of the defendant's success resulted from misappropriation. This often requires expert testimony, economic modeling, and assumptions that defendants will challenge aggressively. Third, lack of comparable licensing evidence. In patent cases, courts can sometimes reference comparable patent licenses to establish a royalty rate. In trade secret cases, licenses are rare, confidential, and context-specific. There's no public market for pricing algorithms or customer lists. Even when licenses exist, they're often bundled with other IP, making comparisons speculative. These obstacles mean that most plaintiffs struggle to prove damages with precision. They can show that harm occurred, but quantifying it to a court's satisfaction is a different matter. Both UTSA and DTSA offer plaintiffs three ways to measure damages: actual loss, unjust enrichment, and reasonable royalty. These aren't mutually exclusive at trial, but they can't be double counted. Plaintiffs typically plead all three, and let the jury decide which best captures the harm. Actual loss focuses on what the plaintiff lost due to misappropriation. This includes lost profits, lost market share, diminished competitive position, and costs incurred to recover from the breach. It's the most intuitive measure. If the defendant stole your customer list and took your clients, your actual loss is the revenue those clients would have generated. But proving actual loss requires showing that, but for the misappropriation, the plaintiff would have earned more. This invites defendants to argue that the plaintiff's losses stemmed from market conditions, competitor innovation, or the plaintiff's own missteps, not from the stolen secret. In Bianco versus Globus Medical, the court awarded actual loss damages based on lost licensing opportunities. Bianco had been negotiating with Globus, and Globus's misappropriation destroyed the deal. The award reflected what Bianco would have earned if Globus had licensed the design instead of stealing it. Unjust enrichment shifts focus from the plaintiff's loss to the defendant's gain. The theory is that the defendant should not profit from wrongdoing, even if the plaintiff can't prove its own losses precisely. Courts calculate unjust enrichment by looking at the defendant's profits attributable to the misappropriation, revenue generated, costs saved, competitive advantages gained. In 3M versus Pribal, a 2001 Seventh Circuit case, former 3M employees used proprietary manufacturing processes to launch a competing business. The court awarded damages based on the defendant's profits, because those profits wouldn't exist without 3M's secrets. The key was showing that the defendant's success was caused by the misappropriation, not just correlated with it. Unjust enrichment is powerful when the defendant's product is closely tied to the trade secret. But it becomes harder to prove when the defendant has added significant value through their own innovation, marketing, or distribution. Reasonable royalty is the fallback measure. It asks, what would the defendant have paid if they'd negotiated a license instead of stealing the secret? This is a hypothetical negotiation, a legal fiction that allows courts to assign value when actual loss and unjust enrichment are too speculative. Courts calculate reasonable royalty using expert testimony, industry standards, the parties' respective bargaining positions, and any comparable licenses, if they exist. The inquiry is, what terms would a willing licensor and willing licensee have agreed to, knowing what they know now? In University Computing Company versus Likes Youngstown Corp., a 1974 Fifth Circuit case, the court awarded a reasonable royalty when the plaintiff couldn't prove lost profits or the defendant's gains. The court held that a reasonable royalty serves as a damages floor, ensuring the plaintiff receives something, even when other measures fail. The downside, reasonable royalty awards are often smaller than actual loss or unjust enrichment. They reflect negotiated value, not the full harm caused by theft. Both UTSA and DTSA allow courts to award enhanced damages and attorney's fees in cases involving willful and malicious misappropriation, but the standards and limits differ slightly. UTSA Section 3B provides, if willful and malicious misappropriation exists, the court may award exemplary damages in an amount not exceeding twice any award made under actual damages. This is discretionary. The court may award, not must. And the language varies slightly by state. Some UTSA jurisdictions interpret willful and malicious narrowly, requiring evidence of deliberate wrongdoing with intent to harm. Others apply it more broadly to reckless disregard or knowing violation. DTSA 18 U.S.C. Section 1836, subsection B, paragraph 3C provides, if the trade secret is willfully and maliciously misappropriated, the court may award exemplary damages in an amount not more than 2 times the amount of the damages awarded. The federal standard is similar, but federal courts tend to apply it more consistently than state courts applying UTSA. The practical difference: DTSA's federal forum and clearer statutory language often make enhanced damages more predictable, but the 2 times cap applies under both statutes. No punitive damages beyond double the compensatory award. Attorney's fees are another key distinction. UTSA Section 4 provides that courts may award reasonable attorney's fees if willful and malicious misappropriation exists, but this is focused on plaintiffs. Some states interpret it to allow fee shifting to defendants when plaintiffs bring frivolous claims, but the text doesn't explicitly require it. DTSA 18 U.S.C. Section 1836, subsection B parenthesis 3 parenthesis D is broader. If a claim of misappropriation is made in bad faith, a motion to terminate an injunction is made or opposed in bad faith, or the trade secret was willfully and maliciously misappropriated, the court may award reasonable attorney's fees to the prevailing party. Notice the difference. DTSA explicitly protects defendants from bad faith plaintiffs. If a plaintiff files a meritless claim to harass a competitor or extract settlement, the defendant can recover fees. This creates a deterrent against abusive litigation and gives defense counsel leverage in settlement negotiations. The upshot: DTSA's fee-shifting provision is more balanced than UTSA's, which tends to favor plaintiffs. Strategic plaintiffs may prefer UTSA in states where fee-shifting is plaintiff-friendly. Strategic defendants may prefer DTSA for its explicit protection against bad faith claims. Trade secret misappropriation is primarily a civil matter. But when theft is egregious, involves foreign actors, or threatens national security, criminal prosecution is available under the Economic Espionage Act, or EEA, 18 U.S.C. Sections 1831 to 1832. The EEA creates two criminal offenses. Section 1831, Economic Espionage. This prohibits stealing trade secrets to benefit a foreign government, foreign instrumentality, or foreign agent. It's the most serious offense, targeted at state-sponsored theft, industrial espionage by foreign entities, or cases where stolen secrets are sent abroad. Penalties are severe. Individuals face up to 15 years in prison and fines up to $5 million. Organizations face fines up to $10 million, or 3 times the value of the stolen trade secret, whichever is greater. Section 1832, Theft of Trade Secrets. This prohibits stealing trade secrets for commercial advantage, to help yourself or harm the owner economically. It doesn't require foreign involvement. It covers domestic theft, former employees taking customer lists, consultants copying source code, competitors bribing insiders. Penalties are slightly lower but still substantial. Individuals face up to 10 years in prison. Organizations face fines up to $5 million, or 3 times the value of the stolen trade secret. The key difference between civil and criminal enforcement is the burden of proof. In civil cases, plaintiffs must prove misappropriation by a preponderance of the evidence, more likely than not. In criminal cases, the government must prove guilt beyond a reasonable doubt, a much higher standard. This makes criminal prosecution harder to pursue, but also more powerful when successful. When should companies involve the FBI? Criminal referrals make sense in 3 scenarios. Large-scale, systematic theft. Not isolated incidents, but coordinated schemes involving multiple actors. Extensive document theft, or organized exfiltration. Foreign involvement, when secrets are being transferred to competitors in China, Russia, or other countries with histories of industrial espionage. The Justice Department prioritizes EEA cases involving foreign adversaries. National security concerns, when the trade secrets relate to defense, infrastructure, or technologies with dual-use applications. The government treats these cases as matters of national interest, not just private disputes. In United States versus Aleynikov, a 2012 Second Circuit case, Sergei Aleynikov, a former Goldman Sachs employee, was convicted under the EEA for stealing proprietary, high-frequency trading code. He downloaded the source code to his personal computer before leaving the company, intending to use it at a new employer. The conviction was overturned on appeal due to technical issues with how the statute was applied, but the case demonstrated the reach of criminal enforcement and the government's willingness to prosecute financial sector trade secret theft. Civil and criminal cases can proceed in parallel. A company can sue civilly for damages and injunctive relief, while the government pursues criminal charges. The civil case moves faster, but the criminal case carries the threat of prison, which is a powerful deterrent and settlement tool. So far, we've treated injunctions and damages as separate remedies, but they reflect a deeper legal choice: property rules versus liability rules. This framework comes from Guido Calabresi and Douglas Melamed's foundational 1972 article, Property Rules, Liability Rules, and Inalienability. They argued that legal entitlements can be protected in two ways. Property rules protect entitlements with injunctions. The defendant must negotiate with the plaintiff before using the asset, or stay away entirely. If the defendant violates the rule, courts issue injunctions to stop them. Property rules give the plaintiff control. They say, "This is mine. You can't use it without my permission. And if you try, I'll stop you." In trade secret cases, injunctions function as property rules. The plaintiff owns the secret. The defendant can't use it without permission. If they do, the court halts the use. Liability rules protect entitlements with damages. The defendant can use the asset, but must pay afterward. The court sets the price, not the parties. Liability rules say, "This is mine, but you can use it if you pay the court-determined value. You don't need my permission. You just need to compensate me." In trade secret cases, damages function as liability rules. The defendant used the secret without permission. Now they pay. The court calculates the value through actual loss, unjust enrichment, or reasonable royalty. The plaintiff doesn't control the transaction. They just get compensated. When should courts choose property rules, injunctions, over liability rules, damages? Calabresi and Melamed argued that property rules work best when transaction costs are low, parties can negotiate efficiently before use. Value is subjective or hard to measure. Courts can't accurately price the entitlement, so they let the owner set the terms. Ongoing use creates irreparable harm. Once the secret is out, no amount of money restores exclusivity. Liability rules work best when transaction costs are high. Negotiating before use is impractical. Value can be objectively measured. Courts can set a fair price without owner consent. Forced exchange benefits society. Allowing use, with compensation, promotes competition, innovation, or access. In trade secret cases, courts usually prefer property rules, injunctions, because trade secrets lose value once disclosed. Compensation doesn't restore competitive advantage. Valuation is speculative. Courts struggle to price secrets accurately. Owners have legitimate interests in controlling who uses their information. But courts sometimes switch to liability rules, damages, when the secret is already widely known, so an injunction won't help. The defendant has built a complex product incorporating the secret, and dismantling it would harm workers, customers, or the public. The plaintiff delayed enforcement, suggesting the harm wasn't irreparable. The plaintiff's real goal is money, not exclusivity, suggesting damages better match their interests. UTSA explicitly allows courts to impose ongoing royalties instead of injunctions in exceptional circumstances that render an injunction inequitable. UTSA Section 2, Part 2. This is rare, but it reflects the liability rule logic. If stopping the defendant would cause disproportionate harm, the court can allow continued use in exchange for court-imposed payments. The Calabresi-Melamed framework helps counsel advise clients strategically. If the client values control and exclusivity, seek an injunction. If the client wants compensation and can tolerate continued use, focus on damages. If the secret is already compromised, damages may be the only realistic remedy. Not every misappropriation leads to litigation. In fact, most don't. Strategic enforcement requires weighing costs, benefits, relationships, and realistic outcomes. Cease and desist letters are the low-cost first step. A well-drafted letter asserts the plaintiff's rights, demands that the defendant stop using or disclosing the secret, and warns of litigation if they don't comply. The letter preserves the right to seek enhanced damages later by documenting willful conduct, and often prompts settlement without filing suit. But cease and desist letters also tip off the defendant. They give the defendant time to prepare defenses, hide evidence, or accelerate disclosure to third parties. In cases where evidence is at risk, plaintiffs may skip the letter and move directly to emergency injunctive relief. Negotiated settlements are the most common outcome. Trade secret litigation is expensive, time-consuming, and uncertain. Settlement allows both sides to avoid trial risk. Common settlement structures include licensing arrangements. The defendant pays royalties to continue using the secret. Cross licenses. Both parties exchange rights to their respective secrets. Covenant not to sue. The plaintiff agrees not to pursue litigation in exchange for payment or other consideration. Settlements work best when the parties have ongoing relationships, vendor partnerships, collaboration agreements, or shared customers, and want to preserve those ties. Full litigation makes sense when the defendant's conduct is egregious, willful theft, bad faith, or refusal to negotiate. The secret is so valuable that anything less than an injunction fails to protect the plaintiff's competitive position. The plaintiff has strong evidence, clear documentation, and can prove damages with precision. Relationships are already destroyed, so there's nothing left to preserve. Litigation is also strategic signaling. Filing suit sends a message to the industry. We protect our secrets. Don't mess with us. For companies in highly competitive industries, that deterrent effect can be worth the cost. Let's recap. Damages in trade secret cases are hard to prove because causation is uncertain, apportionment is complex, and comparable evidence is scarce. Courts offer three theories: actual loss, what the plaintiff lost; unjust enrichment, what the defendant gained; and reasonable royalty, what the defendant should have paid. Enhanced damages and attorney's fees provide additional remedies for willful and malicious misappropriation. UTSA allows up to 2 times damages and discretionary fee awards. DTSA provides similar enhanced damages, but explicitly protects prevailing parties, including defendants facing bad faith claims. Criminal enforcement under the Economic Espionage Act is reserved for egregious cases involving foreign actors, large-scale theft, or national security concerns. Penalties include prison time and massive fines, making criminal prosecution a powerful deterrent. The Calabresi Melamed framework helps counsel choose between property rules, injunctions, and liability rules, damages. Injunctions work best when value is hard to measure and ongoing use creates irreparable harm. Damages work best when secrets are already compromised or forced exchange promotes competition. Strategic enforcement choices, cease and desist letters, negotiated settlements, or full litigation depend on costs, evidence, relationships, and realistic outcomes. Most cases settle. But when litigation is necessary, strong documentation, expert testimony, and clear damages theories determine success. This concludes Module 6. We've covered the full enforcement lifecycle: proving misappropriation, obtaining injunctions, calculating damages, and choosing strategic responses. In the final module, we'll synthesize everything into a comprehensive trade secret protection plan, integrating legal, operational, and strategic elements into a unified framework. Thanks for listening. See you in the next module.